Ladies and gentlemen, my name is Asa Christopher Lubogoa, and today I'd like to make a humble response to Your Excellency on the just concluded case on trying civilians in military courts. And the idea is not to water down what you said, but to have a intellectual dispensation or discussion, a constitution and a legal rebuttal in terms of your justification in trying civilians in military courts. And the idea is that fellow Ugandans, especially the Bazukulu, this is going to be an intellectual and profound statement on the constitutionalism inspired by the principles of silent scholars, but particularly the Constitution itself as the fundamental grand norm. So when men fail to defend the Constitution, they actually do not merely abandon the judgment of governance, they surrender the very soul of justice, allowing tyranny to creep in under the guise of order. So a constitution unenforced is a promise unkept, a betrayal of generations past, and death sentence on freedoms yet unborn. So the measure of moral and intellectual strength is found not in the eloquence of its laws, but in an unwavering result of its people to uphold them. And that is fundamental what we need to talk about. So I'll escapulate in terms of the essence of constitutionalism, emphasizing it as a bedrock of justice in terms of vigilancy and the perils of complacency and what would the variation in specific legal or historical references infer. Let me take this opportunity to engage, as I said, with Your Excellency in terms of an intellectual discourse on the recent Supreme Court ruling regarding the trial of civilians in military tribunals. Your Excellency, as far as your response was concerned, while reflecting on historical perspective in terms of liberation and struggle, is fundamentally flawed in the light of Uganda's constitution. Why? International legal standards and principles of justice that govern a democratic society will have to lend objectivity in terms of my arguments based on sound legal reasoning. Number one, the constitutional framework and the separation of powers. We must comprehend and understand, Your Excellency, that the 1995 Constitution of Uganda is the supreme law of the land, binding all authorities, including the executive, the judiciary, and the legislature. Particularly if you look at Article 126.1, that says that judicial power is derived from the people and shall be exercised by the what? By the court established under this Constitution. And that is substantially important. And then so the Supreme Court, as the highest judicial authority, has the mandate to interpret the law, and its decisions are final and binding. So, Your Excellency, when you claim that Uganda is not governed by judges, but by the people, it is a bit misleading. The people govern through laws, and judges are entrusted with interpreting these laws to ensure justice prevails. So any disagreement with the court decision should actually be addressed through legal means, such as appeals or constitutional amendments, not through public rebuke or even political influence over the judiciary. Number two, if we talk about the unconstitutionality of trying civilians in military courts, is something that we may also want to comprehend. The Supreme Court ruling aligns with Article 28, Sub-Article 1 of the Constitution, basically, which guarantees that every person has a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. So military tribunals are not independent courts in the sense of, contemplated by the Constitution. They are specialized forms meant for military personnel and are not suited to try civilians. And then if you argue in light of Article 210 of the Constitution that provides that the military courts are established for the purpose of maintaining discipline within the armed forces, nowhere does the Constitution extend this jurisdiction to civilians. So trying civilians in military courts violates the principle of natural justice, separation of powers, and the right to fair trial as enshrined under Article 44C, which explicitly says that the right to a fair hearing cannot be derogated from under any circumstances. Now, Your Excellency, if we argue in terms of international law and Uganda's treaty obligations, Uganda basically is a signatory to several international human rights instruments that prohibit the trial of civilians in military courts. Yeah? Let's, for example, look at Article 14 of the International Covenant on Civil and Political Rights, the ICCPR, that guarantees that every person has a right to be tried by a competent, independent, and impartial tribunal established by law. Yes? Now, let's also look at the African Commission on Human and People's Rights, the ACHPR, that has repeatedly ruled that military courts should not have jurisdiction over civilians. In the case of, for example, Media Rights Agenda versus Nigeria, which is 2000, the ACHPR held that military tribunals lack the necessary independence and impartiality to actually try civilians. Yes, let's look at the argument in light of the United Nations Human Rights Committee that has also consistently advised against trying civilians in military courts, affirming that such trials actually violate the process of trial as far as those rights are concerned. Yes? Now, obviously, Uganda, as a member of this international community, is bound by these legal instruments and therefore must uphold these obligations. Yes? Another argument, Your Excellency, that I'd like to bring to your notice would be in light of what they call the flawed argument of the guns and military jurisdiction. Yes? You presented that as an argument in light of what we read from your Twitter account, or X for that purpose. We could argue and say, Your Excellency, you argue that civilians found in possession of guns should actually be tried in military courts before guns belong to the armed forces, and this argument lacks substantive legal merit. How? The Penal Code Act, for example, and the Firearms Act already provide adequate legal framework for prosecution of crimes involving illegal possession or the use of firearms, and therefore, in my opinion, that would be a duplicity, one or the other. Civilian courts are competent to handle such cases without compromising national security. Yes? And then the aspect of the principle of proportionality in terms of legal jurisdiction that dictates that a civilian's offense should actually be handled within the civilian judicial system, not under a system designed for military discipline. And that is something, again, Your Excellency, fundamentally important. And these are the things, by the way, that you fought for, Your Excellency. So we are just strictly, operating within the prisms of the vision that you have. The argument that military courts help to discipline, for example, Karamoja, is an admission that these courts were actually used as tools of repression rather than justice. The rule of law cannot be sacrificed for expediency, something that is important to note as well. And the danger of executive overreach and judicial independence. Yeah, the president's call in terms of, to the Attorney General to amend the Constitution and the laws to facilitate the trial of civilians in military courts is actually extremely concerning, Your Excellency. And the judiciary exists to uphold the rule of law, not to serve political convenience. Yeah? So the doctrine of judicial independence enshrined under Article 128 of the Constitution prohibits the interference of the executive in times of judicial matters. So the argument here, Your Excellency, is that the attempts to alter the Constitution to suit a particular political or even security agenda undermines democracy and erodes checks and balances that are essential for good governance. Uganda has already witnessed constitutional amendments that have actually removed things like term limits and age limits, moves that have actually weakened the constitutionalism as we talk about. So the proposal would further even erode judicial integrity. So I would rather, Your Excellency, that you comply with what the law has said. Because after all, this is your own baby, not so. Now, if we argue in terms of the flawed comparison with the Western legal system, Your Excellency, the president's attempts to compare Uganda's legal system with Western countries in terms of stance, for example, same-sex marriage is actually misplaced. Why? Legal systems operate based on their constitutions, and fundamental human rights are not subject to arbitrary modifications based on political preferences. So the real comparison should be with how mature democracies uphold due process, judicial independence, and civilian oversight over the military. My point here, Your Excellency, is that in terms of upholding constitutionalism and the rule of law, the Supreme Court's decision is not, I repeat, is not an attack on national security or on an endorsement of criminality, as your statement suggests. Instead, it is a reformation of constitutionalism, due process, and human rights. My argument, Your Excellency, is in light of trying civilians in military courts, it violates Article 28, the right to a fair hearing, violates Article 44C, non-derogable right to a fair trial, it violates Article 126, judicial power to be exercised independently, it violates Article 210, military courts for the discipline of what? Armed forces only. The operative word here is only. So it also contradicts international legal standards that Uganda is bound to respect. So the correct legal recourse is to strengthen the civilian judicial system, not to expand military jurisdiction in an unconstitutional manner. Fellow Ugandans, Bazukuru, the point is, the foundation of a free and just society is the rule of law, not the rule of power. Our duty is to defend the Constitution, protect judicial independence, and to ensure that no citizen, regardless of their crime, is denied their fundamental right to a fair trial in a civilian court. Uganda, in my opinion, must remain a constitutional democracy and not a military state. My name is Isaac Christopher Lubogo. Find most of these in our book here, saying the executive constitutional mandate, demystifying the founding owner, okay? And you can find it at lubogo.org, suegeneslawup.com, Amazon, Scribd, and everywhere in the world. This is the biggest constitutional law book right now we have in Uganda. Perhaps it's the locus clacus right now. It's a must read for everybody who is interested in constitutional law. Once again, my name is Isaac Christopher Lubogo. God bless you and thank you for your attention.